We will go on the record in the matter 26 CF52, State of Wisconsin versus Brandon Bearhart. The state appears through Assistant District Attorney Jose Vila in person. Mr. Bearhart appears in person with counsel Daniel Chapman. We're set today in this matter for a status conference. Mr. Chapman, please update the court.
Your Honor, I have discovery and I have an offer. The offer will involve Mr. Bearhart doing an assessment and follow through with treatment. He is actually already engaged to go to Coinga, if I'm pronouncing that correctly, for 60 days of inpatient. When we come back, we can do a plea and sentencing.
Okay. Is it plea and then costs?
Yes. Plea to a misdemeanor and costs.
Okay.
This is a Mr. Schmidt case, if that helps for scheduling.
Thank you. I could do October 5th at 1:45.
You'll be done by then, right? I have to be in Hudson that afternoon.
What about at 9?
That would be fine.
October 5th at 9. All right, you can come get your notice and you're free to go. Thank you.
Assuming everything goes according to plan on being there about 15 minutes early, and we'll have some paperwork to go through. Thank you.
Mr. Lowry? We will go on the record in the matter 26 CT18, State of Wisconsin versus Jonathan Lowry. The state appears through Assistant District Attorney Jose Vila in person. Mr. Lowry appears in person with counsel Daniel Chapman. We're set for a status conference. Mr. Chapman, please update the court.
Your Honor, the state is trying to track down some additional body camera footage for me so I can decide whether or not there's a viable motion to suppress evidence.
Okay. How long do you think it's going to take to get that, Mr. Vila?
It's Mr. Schmidt's case.
All right.
I think if you gave me a status date on the September 28th date, I would know well before then whether they're going to find it or not and what that means for Mr. Lowry's case.
I cannot do it on the 28th because that's an ADA week, but I could do September 24th at 9:15.
Before we dive in, just a quick note, this commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned, it's about to get intense. We're already seeing multiple defendants, different charges, treatment discussions, evidence issues, and critical procedural decisions. And as this hearing continues, one defendant is about to face a major decision involving the right to a preliminary hearing, while another will have to answer questions about representing himself in court. Pay close attention, because these seemingly routine hearings can carry very serious consequences.
That would be just fine.
September 24th at 9:15.
That work for you? Okay.
All right, we will see you then. And come get your notice and you're free to go. Mr. Roy.
Sure.
We will go on the record in the matters 26 CF80, 26 CM53, 26 CM72, 26 TR05 and 06, 26 TR153, 26 TR365, and 366, and 367, and 368, and 369. State of Wisconsin, County of Burnett versus Tevin Roy. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Roy in person with counsel Daniel Chapman. We're set here today in these matters for status conferences. Mr. Chapman, can you please, end initial appearances, I guess, in the 26 CF 80, 26 CM 53, and 72 cases. Mr. Chapman, were you able to go over the criminal complaints in those cases with Mr. Roy?
On the felony matter, yes. I did not realize I had been appointed on 2 misdemeanors as well, so I did not review those with him, but
I can print those out. One
Thank you.
is battery,
have you seen those? Okay.
and the other is operating without a valid license, second within 3 years, possession of THC, and paraphernalia.
Yes, if I can just review those quickly, I'm prepared to go forward.
There you are.
Just making sure. Is this from the same incident as the OWI? No, this, January 1st.
Anderson, are you ready?
No, different days. Well, it's 30 days. Penalty on that is 6 months. Penalty on that is 9 months. We'll take care of them all. It's just going to plead not guilty today. Yes, Judge, we're ready to go forward.
He understands all charges in those 3 cases and the maximum penalties.
He does, Your Honor.
Does he waive formal reading?
We will waive reading on each of the 3 complaints and enter not guilty pleas to the misdemeanors.
Not guilty pleas will be entered on his behalf to the misdemeanors. With the felony, he's entitled to a preliminary hearing. Is he waiving time limits?
Actually, Judge, he's prepared to waive the preliminary hearing outright today.
All right. So, Mr. Roy, do you understand what it is to have a preliminary hearing?
Yeah.
The burden is on the state to prove a felony was probably committed and probably committed by you. Do you understand that?
Mhm.
Is that a yes?
You gotta say yes.
Do you understand that by waiving your right to a preliminary hearing, you are agreeing that the state can at least meet that burden?
Yes.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, would be able to call witnesses to testify for you. He'd be able to discover things about your case, which could include some defenses, and he could produce evidence on your behalf. But do you understand for today's purposes, you are giving up those rights?
Yes.
Do you understand that if the state does not meet its burden as to those felonies, I could amend them to misdemeanors or dismiss them altogether, but you're giving up those rights?
Yes.
Do you understand that as a result of waiving your right to a preliminary hearing, that these matters will be bound over to future proceedings, which could include a trial?
Yes.
Do you understand that once you give up your right, it is forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing.
This is a major procedural moment. By waiving the preliminary hearing, Mr. Roy is giving up an important opportunity for his attorney to question the state's witnesses, investigate potential defenses, and challenge whether the state has enough evidence to proceed on the felony allegations. The judge carefully confirms that he understands those rights before accepting the waiver and binding the case over for future proceedings. Would you have given up that hearing, or would you want every available opportunity to challenge the state's case? The transcript then continues unchanged, including the arraignment, not guilty plea, and September 24th scheduling.
Yes.
And voluntarily.
Yes.
I will find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Vila?
I'm going through and attempting to file it. I'm having a technological issue on my end, so it will be filed after this hearing, Your Honor. But it will likely mirror the criminal complaint.
Mirror the criminal
It
complaint.
will likely or it will?
Yeah.
It will mirror the criminal complaint. My apologies.
All right, proceed with an arraignment today or set it for another date.
Given that the charges will mirror the criminal complaint, Mr. Roy is aware of those charges. We can go forward today.
All right, he understands those charges and maximum penalties.
Yes, he does.
Waives
And
formal reading.
he will waive reading and plead not guilty.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Let's schedule you for your September 24th at 9:15.
Thank you. And can all the traffic matters tag along?
They sure can. September 24th, 9:15. We'll see you then. Come and get your notice and you are free to leave.
I believe that was my last one.
I believe it is too.
Thank you.
Thank you.
Questions, Mr. Roy? Okay, give me a call if you do.
You want this microphone on?
Yes, please. I'm sure that is probably better. I don't know how they got off. Unless our power went out. Do I have the jail or is this just kind of waiting? And I have Miss Pulaski here. This would be, there's an allegation of threat to cause bodily harm to certain individuals involved in the court or legal system. Would be in victims' rights compliance.
As far as I'm aware, there is no victim that's coming forward today.
All right, Ms. Pulaski, you can come on up here. We will go on the record in the matters 26 CF 66, 26 CT 10, State of Wisconsin versus Regina Pulaski. The state appears through Assistant District Attorney Jose Vila in person. Ms. Pulaski appears in person without counsel. Warrants are quashed. Ms. Pulaski, you have felony allegations in the new case and you're here for an initial appearance. Were you going to apply for a public defender?
I didn't know if I'd still qualify because I didn't before, but I don't have the same job. So yeah, I was.
Well, yeah, so you don't have a job?
I do have a job, but I don't have the same one. I was making way more money at the casino.
Okay, so maybe you may be able to qualify, but you're not entirely sure. So let's do this.
And I was talking to a guy from at the 10th hole, but he practices in Minnesota and he was going to give me a number to one of his people that he talks to in Wisconsin, like a friend of his, lawyer.
Okay, an attorney? Either I can move it to this Wednesday at 1, or I can't hear it until,
I could go forward right now.
well, because then the time limits start to run with the prelim. So I'm okay if you want to move it to August 12th or this Wednesday.
I mean, this Wednesday's kind of close.
I'm just saying because the public defenders will be here.
Okay,
And so then I know that you can meet with them and
Okay.
apply.
I can do that then.
So you can do it this Wednesday?
Yeah.
All right, so let's just move it to Wednesday at 1.
Fine.
So be here and then you'll be able to speak with the public defender and see if you qualify. You can still talk to that friend, 10th hole
Right.
friend, lawyer friend, even if you have a public defender, but then we know we can get it moving so you don't have to be in this standstill. Now, you were working on getting your license.
Oh, yeah, but then I had a hiccup and had to pay extra money to get out, and then I had a warrant and I had to pay that money. And
So your hiccup is you need to pay money to get your
Yeah.
license? What else do you have to do other than?
I
pay
still
money?
got to do the Mad Impact panel.
Okay, your impact panel.
Yeah.
You call Aurora just to make sure that you're still on the good to go to do that,
Okay.
because you only have so long to fit it in,
Okay.
because you don't want to have to start all over again. So I
Right.
would call Aurora today, okay?
Okay.
And just find that information out and do the impact panel if you still have that time to do it. Because then at least you're working towards getting your license and that's one
Right.
thing off your list, okay?
Yep.
So we'll see you here this Wednesday at 1. Come get your notice and you're free to go.
Thank you.
Mr. Mosier, CT11, State of Wisconsin versus Guy Mosier. The state appears through Assistant District Attorney Jose Vila in person. Mr. Mosier appears in person without counsel. We're set for a status conference. Mr. Mosier, where are you in the process of getting your license?
I'm no closer than I was last time because I can't get a thing made up with Douglas County for my child support. All I owe is arrears, but she doesn't want
A payment plan?
She'll set up a payment plan, but she won't give me a thing for my license right away. She said it'd probably be about 6 months. I'd probably have to make like 6 months.
Okay, so I think the offer is then to plead to the charge for costs or trial.
Oh, I don't want no trial. Can I plead to no valid driver's license?
You don't negotiate with me. I'm not involved in any of those things. That would be with that gentleman right there. If you need
And
some
we'll
time.
settle it today.
It's an OAR. It's for cost only.
And then what else? Well, what comes with the OAR?
Well, what he's saying is plead to the misdemeanor operating while revoked for costs only. So it wouldn't be jail or anything, wouldn't be the recommendation to the court.
Okay, and then how long does that make me for my driver's license again?
That's a question for the Department of Motor Vehicles.
Oh, okay. So probably like 6 months I'll be,
Probably.
okay, well then that would probably put me close to I can have my driver's license again because then I'll be on Social Security.
Okay, that would be good. So hopefully don't drive before then. So do
Nope.
you wish to accept the state's offer?
Yes,
Do you understand that an attorney goes to law school to learn how to negotiate and to look for defenses and to argue and present evidence?
yes,
Do you understand that not having a lawyer means that you'll have disadvantages?
yes,
Do you wish to represent yourself here today?
yes.
How old are you?
61.
Can you read, write, you understand the English language?
Yes,
Any drugs, alcohol, or other medications in your system?
nope,
Do you understand that you would be able to go and have a trial? You'd be able to have an attorney or yourself cross-examine the state's witnesses or call witnesses to testify for you. You'd be able to testify on your own behalf or remain silent and not have your silence used against you. You'd also be able to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you'd also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all those rights you're giving up here today?
yes, Your Honor.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes,
Do you understand that the state would have to prove on or around January 29th, 2026, that in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you did operate a motor vehicle on a highway or roadway of this county and state during that revocation period or thereafter, and the revocation was a result of an OWI or similar offense?
yes, Your Honor.
You understand the maximum possible penalty could be a fine of up to $2,500 or 1 year in the county jail or both.
Yes, Your Honor.
Do you understand that the agreement here is a recommendation to the court for costs only? But do you understand I'm not bound to follow that?
Yes, Your Honor.
I could sentence you to the maximum possible penalty today if I thought it was warranted.
Yes,
Are you admitting here today you in fact did operate a motor vehicle while revoked
yes, Your Honor.
and you knew it was revoked?
Yes,
Has anyone made any threats or any promises to you for you to plead guilty today?
no, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes,
and voluntarily.
yes,
Do you have any questions for Mr. Vila or for the court?
no, Your Honor.
As to count 1, operating while revoked, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of operating motor vehicle while revoked. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. Mr. Mosier is here accepting responsibility for his actions today. Looking at the timeline for this case, it's a pretty quick turnaround for as far as OARs go. And given the level of offense that we're dealing with, I think costs are more than appropriate here, and the additional license penalty that will be assessed are more than appropriate to protect the needs of the public. I would ask the court to follow. Thank you.
Thank you. Mr. Mosier, anything you want to add or you want to let the court know?
No, I'm just gonna work on getting my job.
I really want you to get your driver's license.
I really want him
Mosier.
to.
It's not very fun to see you here.
I know, I like you, but I don't like to come here to see you either.
Same here. I prefer you not. Yes. So I think costs are appropriate. What the court is going to do is you're pleading guilty, accepting responsibility pretty early on. So I'm just going to assess $250. That's the DNA surcharge with a slight bit of a fee attached because we have to pay for this somehow. I'll waive the rest. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need you to go to the jail and provide your DNA.
I think they have that.
You still have to go every single time to give your DNA, or I have to order it. And they just have to make sure that they have it. But it also says I need fingerprints anyway. With every single case, I have to get fingerprints. So go ask, you'll get paperwork, go say I need to give fingerprints, my DNA. You have the right to request your DNA be expunged through a written letter to the Department of Justice, not to the court, to the Wisconsin Department of Justice. You can Google it. It's easy to do. Again, 20 days to appeal. Am I missing anything?
No, Your Honor.
Mr. Mosier?
Nope.
Come get your documentation, fingerprints, DNA, you're free to go.